Okay, so give them your attention, please.
Hi class, we will be talking about law. My name is Rosie, this is Joey, and this is Lee. We're going to be covering age, national origin, and pregnancy discrimination, vocational rehabilitation, fair labor, and pay act, equal employment opportunity. Anyway, age discrimination. Has anybody didn't get hired or didn't get job opportunity because you were too young? This involves treating someone unfairly, and it's because of his or her age. What is an example of age discrimination? Teasing, offhand comments, they create a hostile environment towards the employee, and that is harassment. Who can be a harasser? Anyone at all. Age discrimination in the Employment Act forbids discrimination against or for anyone 40 years and over. It states that the law will protect younger workers as well in certain states. Would you ignore a low qualification just because of his or her age, or if their person is younger or older? My mother is 63 years old. When she was 49, she was getting paid $14 an hour. But now she's making $10.50 because supposedly she doesn't do the duties of a younger person. She is a home health aide, so they help assisting older people. So they say because she's 63, she probably needs help as well. That's why they overpay. Now she's working 2 jobs. Do you or anyone have an accent? Because I do. Do you know anyone that wasn't hired because they're not what they're looking for? Or because of their ethnicity or where they're from? No one should be denied employment opportunity because of their birthplace, culture, ethnicity, or even their accent. EEOC enforced the federal prohibition against national origin discrimination in employment under Title VII and Civil Rights Act of 1964. So should people be Chinese just to work at a Chinese food factory, or be Caucasian to work at an Italian restaurant? As long as the applicants can accomplish a duty or job offer, they should be having equal opportunity. So a friend of mine is Caucasian. She applied to work at a nail salon. She wasn't hired because supposedly she's not Asian. And she has a cosmetology degree. I believe she should be hired instead than certain people who doesn't have the qualifications. I was fired from a position that I applied for at Burlington County, Morristown, Morrison, but once I said, oh, I'm from Camden, they doesn't want to hire me because I will give them a bad reputation, even though I was qualified, overqualified too, just to work at a front desk. Is anyone pregnant or have a child? I know I do and someone else do. Do you ever got discriminated? Or because you don't have you can't lift weights at a certain pound or something? Pregnancy Discrimination Act is under Title VII. It forbids discrimination based on pregnancy, whether it's hiring, firing, pay, opportunities, assignment, promotion, training. Pregnant employees must be permitted to work as long as they are able to perform their jobs. Employer may not require her to remain on leave until the baby's birth because they were absent from work or result of pregnancy-related issues. Under U.S. Department of Labor, Family and Medical Leave Act of 1993 allowed new parents, including foster or adoptive families, to have 12 weeks for family leave. However, some employers may have workers for up to 12 months. Employer must treat the employee the same as any other disabled employees that are unable to perform their job duties. Employees should be treated exactly the same as employees that are disabled, whether it's paid or unpaid leave. I was discriminated again, this time because I was pregnant. Supposedly, they were supposed to let me work because I couldn't do this, do that. And that was 2 weeks after I told them I was pregnant. Also, I was one of the employees with the most experience in the job place, but I didn't get a raise because I was on leave after I had my child. So everybody had a raise, $2 raise, but me. Once again, my name is Rosie. I covered age discrimination, national origin discrimination, and pregnancy act discrimination. And now to Joey.
Thank you, Rosie. So, my name is Joe. Today I will be talking to you all about the Vocational Rehabilitation Act of 1973, the Fair Labor Standards Act of 1938, and the Equal Pay Act of 1963. So I'm going to start with the Vocational Rehabilitation Act. It was established in 1973, and it helps eligible persons with a disability pursue post-secondary education, employment, and independent living opportunities. This is put in place to correct the problem of discrimination against people with disabilities. Now, a disabled individual is any person with a physical or mental impairment which substantially limits the one or many major life activities. Now, a person with a recorded history or who is known to have any of these impairments is also covered under this. There was a case in Nassau County, Florida versus R-Line. After the case, it was determined that individuals with certain contagious diseases are also considered disabled individuals. Some of these diseases include AIDS, diabetes, drug addiction, alcoholism, and blindness. Title V of the Act requires private employers with federal contracts over $2,500 to take affirmative action and hire individuals with a mental or physical disability. As long as the person is still qualified to do the job, the employer must provide the reasonable accommodations or services. In New Jersey, we have the NJ Division of Vocational Rehabilitation Services, and they are funded by the federal government and the Federal Rehabilitation Service Administration. Some of the services or counseling options they provide are psychological counseling, physical restoration therapy, driver training, home or vehicle modification services, substance abuse therapy, assisted job training, and emotional restoration services. Next, with the Fair Labor Act, it was established in 1938. It had 5 main points to it. They wanted to cover the minimum wage, overtime pay, record keeping, youth employment, and the Equal Pay Act. Now, with minimum wage, in July 2009, the federal minimum wage was set to $7.25. In New Jersey, we're a little bit more fortunate. Our minimum wage was raised to $8.38 as of January 1st of this year. There are some exceptions for tipped workers and teenage trainees. Overtime pay covers all non-exempt employees. For every hour that a non-exempt employee works over their work threshold, they are to be paid time and a half. So any hour past 40 in a typical 7-day work week is considered overtime. There are 7 categories of exempt employees. The exempt employees could be executives, administrative employees, learned professionals, creative professionals, computer employees, outside sales employees, and highly compensated employees. Generally, they're all paid under salary rather than hourly. For record keeping, there are certain types of records that need to be kept for at least 3 years' time. Some of the basic records are the employee's full name and social security number, their address, including their zip code, their sex and occupation, and their birth date. Children under 14 are not under any circumstances allowed to be employed. Age 14 to 16, children are allowed to be employed for a limited amount of hours per day outside of school hours. 16 to 18, they're allowed to work whenever, as long as it's a non-hazardous occupation. The Equal Pay Act, which is administered and enforced by the EEOC, was amended to the FLSA in 1963. Prohibits pay discrimination based on sex and states men and women must be paid equally for substantially equal work. The Act allows for individuals to file for pay discrimination under Title VII of the Civil Rights Act. Employers are legally prohibited from retaliating against any employee who decides to take action against discriminatory practices in the workplace. Now, why does this still matter today? In 1963, when the Act was established, women made 59 cents for every dollar that men made. In 2013, that's only at 77 cents now for every dollar that men made. That's an increase of less than 4% for 4 cents per decade. They get away with this because they claim that jobs have to be substantially equal, and they're determining that based off of skill, effort, responsibility, seniority, merit, production levels, and working conditions. So it can be skewed pretty easily. Back in 2009, the House of Representatives approved the Paycheck Fairness Act. It's an update to the EPA and requires employers to demonstrate why certain pay differentials are there aside from sex. It was rejected in the Senate in 2010, and since then has been rejected 4 times. The Republicans who argue against the act say that the bill would discourage employees from hiring women out of fear of lawsuits. All right, so in summary, today I talked about the Vocational Rehabilitation Act, the Fair Labor Standards Act, and the Equal Pay Act, as well as touching a little bit on the Paycheck Fairness Act. And next up is Lee, who's going to talk about the EEOC as well as the Civil Rights Act.
Thank you, Joe. My name is Lee Robledo, and I will be discussing the Equal Employment Opportunity Civil Rights Act of 1964 and the Civil Rights Act of 1991. A brief summary of what I'll be discussing today is starts off with the description, the laws, the coverage, and then how they enforce it. Also, the Civil Rights Act of 1964 and 1991, a brief summary of them, and a personal experience I faced dealing with the EEOC in the workforce. The EEOC description is they're responsible for enforcing federal laws dealing with discrimination against any applicant or employee based on a discriminatory trait such as race, color, or religion. They also make it illegal for those who make a discrimination complaint against an employer, those who file charges against the employer, or any employee who actually participates in assisting the EEOC in an investigation. The EEOC laws cover a variety of laws and regulations. This is just on the basis of any discrimination, but they actually do it to protect employees from their employers when they face a discrimination claim. Certain laws are like Equal Pay Act, Pregnancy Discrimination Act, and the American Disability Act. These are just all enforced by the EEOC, just protect employees. EEOC laws, certain laws are covered by, or certain work situations are covered by certain laws. Certain situations such as hiring and firing can be covered by one law or even multiple laws. And this is just, so any chance an employee gets stuck in a discrimination practiced by the employer, they'll be protected in any case. Those employers who are covered by the EEOC are those business sector, private sector employers, employment agencies, labor unions, and state and local governments. There's a variety of ways to be covered by why you're covered. If the type of employer you are, since what I just stated, the number of employees you have, and what law and type of discrimination occurred. This allows for employers who have a lot of employees to not be discriminated against because they can't really handle different discrimination employment practices. Also, when a violation happens, the EEOC is responsible for receiving the claim, investing the claim, and then resolving all charges and handling the situation from further there. Now into the Civil Rights Act of 1964. It was legislation process to prevent any discrimination against any protected class individual. This allowed for anyone to be equally treated in the workforce or even in public. There was 11 main features to the Civil Rights Act. Title VII is the one that pertains mostly to our class. It deals with the prevention of discrimination by employers because of their protected class. 1991 Civil Rights Act was an extension of the Title VII. This allowed for further protection due to any discrimination claim to go to trial by jury and allowed them to be rewarded emotional distress. And also the jury had a limitation on how much people were rewarded. The first emotional distress damage is compensatory damages. This is monetary sums that are compensated to the plaintiff for any harm that was caused by the employer. Such examples are medical expenses and court fees. The next one is punitive damages, which is damages that are only for punishing and preventing reoccurrence of any discrimination by the employer. This only is allowed to happen if the employer intentionally tried to cause discriminatory harm to this person. My example I was working for Canada Dry, and a protected class employee was made a complaint that minority drivers were getting unfair routes. An EEO investigation happened, and they actually found out that tenure was the reason for the type of routes they received. So this was actually pre-established in the system. So there was no there was no reasonable cause for discrimination complaints. So the charge ended up being nullified. And a brief summary of what I just went over and some key bullet points is that EEOC enforces federal laws against any employee